do you say your first name?
Isis.
Isis. And you're Isis Traddles?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
She will, Your Honor. Oh, I gave you.
I got her. Ms. Traddles, in cause number 25, DCCR 1478, you're charged with a state jail felony offense of injury to a child from July 21st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, which would include entering and successfully completing an anger management program. You understand?
This opening moment is extremely serious. Injury to a child is one of the most emotionally charged charges court handle. But notice something important here. The judge carefully confirms that the plea is voluntary and fully understood. That's legally required because once a guilty plea is accepted, the defendant usually loses the right to appeal. Deferred probation might sound lenient, but it's actually a high-risk opportunity. If she violates any rule, this case could instantly turn into a prison sentence. Do you think deferred probation gives people a real second chance or just delays punishment?
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Judge, I'm sorry to interrupt the plea. Your Honor, I just realized that there's information in my file that indicates restitution for the hospital bill for the child. I shared it with Mr. Parker. It's $346. I don't know if we want to maybe put this on hold.
Well, so I'm going to reset it for sentencing, and that can be confirmed with probation between now and sentencing, and then just make sure they know about the restitution amount. So if there's any restitution between now and sentencing, they'll get that figured out, and it will be ordered if there was any restitution.
Here's a detail many viewers overlook: restitution. Courts often require defendants to financially compensate victims for damages like hospital bills. Even though the amount sounds small compared to the charge, restitution symbolizes accountability beyond criminal punishment. It's the justice system trying to repair harm, not just punish behavior. Should financial restitution be mandatory in cases involving injuries, or does it sometimes place unrealistic pressure on defendants trying to rebuild their lives?
You understand?
So you say I'm gonna have to pay that?
What? I'll tell you. They're going to look into that. They're going to reset it.
They're going to look into it. If there was something that had to be paid or is owed because of what you did that insurance didn't cover or whatever it is, then yes, you're going to have to pay it. And I'm going to make that notation on the agreed punishment recommendation that I've said restitution to be determined, if any.
Your Honor, we're requesting a personal bond.
Hold on, let me get there.
I'm sorry.
Okay, did I already ask about
Immigration.
immigration?
That's what you did, Judge.
Okay, state tenders number 1.
Okay.
It's admitted. Any evidence that Ms. Traddles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Cole.
This is a huge turning point. The judge grants a personal bond, meaning the defendant can leave jail without paying money, but it comes with strict behavioral conditions. This shows how judges balance fairness and public safety. The restriction on unsupervised contact with minors is especially significant. It protects potential victims while still allowing the defendant freedom. Personal bonds can be a powerful trust signal from the court, but breaking that trust usually leads to severe consequences. Would you consider this decision compassionate or risky?
Coleman, what is your position with regard to bond?
The state's unopposed to either lowering the bond or a personal bond. Judge, she has no criminal history. In fact, information in my file indicates that she was cooperative with law.
So where is the child now? Who's he living with?
His mom.
Okay, so this wasn't your child? Do you have any children?
No, ma'am.
All right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make that a personal bond, which means you do not have to pay any money to get out. If you don't show up to court, you're going to have to pay the $1,000 and they'll come after you. But you'll just be released today. But there's some very important things about that. So the first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If for some reason it's later in the day, then go first thing tomorrow morning. But if it's not, then go straight there this afternoon. You'll get some paperwork today that tells you where to go. If for any reason you don't follow through with that report, then you run the risk of me not accepting the plea agreement and things could be much worse. You understand? Also, if you're arrested for anything between now and the time that we come back for sentencing, you run the risk of me not accepting the plea agreement. You understand that also? And then finally, between now and sentencing at least, I am going to order that a condition of your bond is that you not have any unsupervised contact with any child under the age of 18. Now, that obviously may change in the future, but just for between now and then, I don't want any unsupervised until I know what we have in place and I can find out more about the case. Understood? All right, you can go back with the bailiff. You're Melissa Taylor.
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
She will.
Ms. Taylor, in cause number 25, DCCR 1693, you're charged with a third-degree felony.
Now we shift from violence-related charges to addiction-driven crime, and courts often treat these differently. Instead of focusing only on punishment, the judge is clearly prioritizing rehabilitation through treatment programs. Deferred probation here offers a life-changing opportunity. Complete treatment successfully, and a felony could disappear from her record. But failure means facing up to 10 years in prison. Addiction cases often raise one huge debate. Should the legal system focus more on recovery or deterrence?
Offense of possession of a controlled substance from March 9th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for a 10-year deferred probation. Is there no fine on this one?
I'm okay with waiving the fine.
All right, there would be no fine on this case, and you would be required to follow all of the rules and conditions of probation, which, as you guys have said, is unagreed as to treatment, but that we've talked about. What I'm inclined to do is the substance abuse track of the ISF program. Is that your understanding?
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Taylor is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I am going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You're ordered to follow all of the rules and conditions of probation, which include entering and successfully completing the substance abuse track of the ISF program. In addition, as your follow-up treatment, when you get out, you will be required to enter and successfully complete the JCDI program. So you're going to get out, you'll have all the tools, you're going to get tools while you're in custody, you're going to get out, you're going to have even more tools so that you can be successful and get off drugs for good, be a productive member of society, and not end up with felony convictions on your record and going to prison. And if you do all of that, just like we talked about in the other case, this is a great opportunity because you don't have the conviction on your record. If you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition in this case, you'll be brought back into court, you could be found guilty, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you, in that case, the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. Yes, ma'am?
May I speak?
Let me, hold that just a second. Let me take, because I'll get sidetracked and then I won't do what I need to do legally. So now, for probation, in cause number 24, DCCR 2311, I am going to grant that motion to modify the probation order to change that from SafeP to ISF, substance abuse with JCDI as aftercare.
Will you give me the call number?
24 DCCR 2311.
Judge, I think there may also be another probation that she's on, a different cause number.
I'm not sure.
I thought we pled her to a state jail and a
Can y'all look,
higher level
please?
felony. I just don't want, I don't want to get skipped over if there's another.
If she's on probation for more than that one, if there is another, and then the same order goes for all. If it was SafeP, that can be
No, just this one or two.
switched from SafeP to ISF substance abuse with JCDI as a, the problem is if it's a, do y'all think there's one? Because it might be the time that she's on probation could be an issue.
I
Okay.
could be wrong.
Okay, we'll double check it. If she is, that'll be a condition. It'll be switched from SafeP to ISF also. Okay, yes, ma'am.
Yes, ma'am. So I have been incarcerated for the last 8 months in Jefferson County Correctional. During the last 8 months, I've held a trustee position for 6 of those 8. There are no programs for rehabilitation for women like myself that spend 8 to a year incarcerated. There are none. The completed literature that I put down, I went out of my way to obtain that, get those shipped in to me, to reach out to an outside sponsor to review my packets that I went through. I have, whether you go to a 9-month program, a 6-month program, or a 3-month program, the desire of the individual to change and putting these into application are what actually creates lasting change. Otherwise, they're just books that I've read.
Sure.
If you can ask me anything about these books and I can tell you how I've changed and how they've changed me and what they've done. I realize that my addiction is a terminal disease that will kill me. And it is a lifelong recovery process. And that if I don't completely abandon myself to my higher power in a recovery program for the rest of my life, that I will end up in prison or dead. I don't have any more options. I agree that I will most likely learn something from ISF. I will learn from any program that I'm ever put against. But I am begging you with the effort that I took, seeing that there's no options for female inmates other than an AA program every other week at best. We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle. I understand the triggers and what made me relapse. I have a phenomenal support system and I am willing to go so far to say that if you give me the color program and if I fail, take this all away and put me in prison for 5 to 10 years.
This is one of the most emotional moments in the entire hearing. Personal statements like this can strongly influence sentencing because they humanize defendants and show accountability. But judges hear promises of change every day. So sincerity alone isn't enough. Courts look for proof through actions, history, and support systems. Her willingness to accept prison if she fails is a bold move and signals confidence in her recovery. Do you believe emotional testimony should influence legal decisions? Or should courts rely strictly on documented behavior?
I don't have it as an option.
Mr. Nichols, so
Big red letters.
So here's the thing, Ms. Taylor, the words that you're saying
Right.
are, I mean, I can tell that you're sincere. I hear people say those words somewhat often. I wish more. Sometimes I feel like they're sincere, others I don't. I agree, there are not programs because jail is just a rotation of coming and going, and it's hard to get programs going because by the time someone gets started, they're probably leaving, and it could be better. I appreciate what you've done. I'm inclined, but here's my fear, is that I don't want to do what you're asking and set you up for failure. So if I do what you're asking and you violate, there's going to be a notation about all of this. Mr. Nichols will remind me, probation will remind me, and there won't be, okay, now I need SafeP, now I need ISF.
I'm that dedicated to my recovery.
You know, I usually have a pretty good memory for these things, Judge. If the court wants to give her that shot, I don't want to have to revoke her. I want her to be successful. I've read what she provided the court. I know it's impressive, the work she's done for herself while in jail. I'd hate to see it all fall apart, though. I mean, I think the case she's on, other case she's on probation for is assault on an officer. And I know there was at least one state jail.
I do have, so 24 DCCR 2177 is another, she's on probation for. There is another probation. And so 24 DCCR 2177, so whatever I do to modify conditions are going to be the same on those. So I guess what I'm going to do, Ms. Taylor, is I'm going to give you this opportunity. It's 100% up to you to take it. Otherwise, you have 3 felonies that you're going to go to prison for. And here's the thing. If you feel like you're slipping and you need more and you go say, I need SafeP or I need an ISF before it ends up with me, that's one thing. That's a hard decision to make. But if you're truly committed to it and you feel yourself slipping that you need inpatient, it's going to be up to you to make that decision to ask for it. If it gets so far that you're here, it's going to be too late. All right, so then I'm going to modify the conditions of all of those probations, including the new case, to order that Ms. Taylor enter and successfully complete the JCDI program and not have to go to ISF or SafeP in any of them. So take advantage of this.
This is a final dramatic resolution for Miss Taylor's situation. The judge offers her a massive opportunity, avoiding prison across 3 felony cases, but places the responsibility entirely on her shoulders. Notice the warning. If she feels herself slipping, she must ask for help before violating probation. Courts often give second chances, but they rarely give third chances. This decision blends compassion with accountability, which is one of the hardest balancing acts in criminal justice. If you were in her position, do you think pressure like this motivates recovery or makes success harder?
I did everything else.
I think so.
All right, good luck.
Yes, ma'am.
There's 2 old probations, the 2 prior ones, and 1 new one. So we've got 3. Morning, are you Tristan Calhoun? Yes. And will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Calhoun, in clause number 25, DCCR 1216, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in clause number 25, DCCR 1217, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Bless you. I have here on the tablet some documents that have your signature on them in each of these cases that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney's office, you will be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind if I follow the agreement. You understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of the cases is for 7-year deferred probations. There would be $500 fines. There would be, you'd be required to follow all of the rules and conditions of probation, including paying any restitution that would be determined between now and when we come back for sentencing, and also having no contact with the victims in either of the cases. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your case, both of them, for sentencing so that the probation department can do a pre-sentence report. Again, that'll give me more information about you, your cases, determine any restitution, and then we'll come back later for sentencing. What's the state's position, Ms. Malfino, with regard to bond based on the nature of those plea agreements?
Judge, I have no objection to the PSI bond in this case. It appears he only has one misdemeanor conviction from years ago. For my review of his criminal history, I would ask, as the court has already stated, that he not have any contact with Sierra Williams or Keithera Fowler. The complainants in these cases, it doesn't appear that these parties know one another. It appears like this is more of a road rage, traffic accident gone wrong type thing.
What was the first name, Sierra?
Sierra Williams and Keithera, Keithera Fowler.
The indictment on that one says Ardwan as the last name. Yeah, that's the 1217. And I can just put both.
Yes, it does, so she must go by both names.
Okay, so Fowler, Ardwan.
Correct.
All right, so
And then
he,
I'm sorry, excuse me.
Sure.
He not possess a weapon because it was involved in this case. I will get together the necessary documentation for their medical restitution, assist PSI.
all right.
I think the car was still dead. They're alleging the
Was-
car.
The motor vehicle,
They're alleging the car was still dead.
let me look at the probable cause.
There's a,
They're-
yeah.
I can't read this. I'm printing something real quick.
Yes, ma'am.
So what I'm going to do while I'm printing that is, Mr. Calhoun, I'm going to reduce your bond in each of these cases to $1,000. If you make those bonds, a condition of those bonds are that you obviously have no contact or communication with Sierra Williams or Keithera Ardwan Fowler. Give me just a second. I'm taking that back. I'm not going to change the bond because there's the potential of some type of upfront, either treatment or cognitive issue. I mean, what happened on this day this is pretty serious. Yeah, and so the bonds are going to remain the same. I'm not going to reduce those bonds. We'll see what the probation, what that report comes back, and if I feel like there's anything that is necessary or would be helpful for you to be able to make better decisions, be successful in the probation, then I'll order that at this time, but I'm not going to reduce the bonds based on what happened that day. All right, you can go back with the bailiff.